Hello and welcome everybody. Thank you so much for joining our webinar here today. We're going to be talking about estate planning. Our specific title is Avoiding the Biggest Mistakes with Wills and Trusts. In today's conversation, we will talk about a basic estate planning topics as well as some more advanced topics on estate planning, specifically long-term care. So before I do introductions, let me just share a story with you. I had a client last year call me up, talk about their mom and dad. Now, their mom and dad was my client. Mom's at home doing fine. Dad needed to go into a nursing home. And they're worried about how to start to pay for this because mom still has her normal cost. Dad now still has a lot of cost. So I'm working with the kids on mom and dad's assets and how do we create this much money to pay those extra bills. Long story short, assuming that there was no change in health got worse, cost of care doesn't go up, things like this, they're going to run out of money in about 3 to 4 years. And that's scary because mom's still in good health and mom's health may change later down the road. So today talking about estate planning is very important to me, helping clients protect their assets, a lifetime of saving money and protecting your assets from a long-term care spin down. That's pretty huge. All right, so we want to talk about that a lot today in today's long-term care presentation. So let me get to my screen ready here. There goes a little introduction. My name is Mark Roberts. I'm the owner of Affinity Asset Management. I'm not here today as the owner of Affinity Asset Management. As a financial advisor, I'm an active and professional money manager for folks that we specialize in a lot of areas with taxes and estate planning. But today, I'm here today representing my nonprofit. I am the director of the Kansas City chapter of F3E. It stands for the Foundation for Financial Education. We created this years ago because it was our way to want to give back to our community, to be able to go out into Kansas City and help folks without having to pitch products or sell products. So when we do a webinar like this, there's no cost, there's no product pitching. It's just here for us to educate you and then to make ourselves available for follow-ups, conversations through the phone, through Zoom or in person, and be able to get those questions answered without having to try to sell product to you. So sit back, relax, enjoy today's conversation. If you have some questions, I want you to write them down. I want you to feel like you can ask them to us. So as we get into this here, let me point out a couple quick things here. On the screen, you're going to have the opportunity to schedule an appointment directly with our featured speaker, Glenn Stockton of Stockton and Stern. And there's going to be a little button on the bottom that allows you to schedule an appointment. And it's going to ask you to schedule a complimentary strategy session with Glenn. And you get the screen that pops up that looks like this. Then you get to select the day that you want. You get to select the time of day. You get to fill in some basic information. And then you get your confirmation back that that's scheduled. Now just know that once you schedule that, we're going to give you a call, we're going to confirm it. Ask you a few questions, make sure that we have your questions ready to go, that we can get the attorney ready for you, but make sure that that appointment day and time still works good for you as well as it does for the attorney. So at any time during the presentation, you can click on that, and it may even pop up a couple of times throughout the presentation. So when you feel it's appropriate and you've got enough information and you say, gosh, I want to talk to these guys, I want to talk to that attorney, click that button. Also want to note that down at the bottom of the screen, there's going to be a box there that allows you to ask us a question. So this is a live webinar, and feel free to ask us a question. We'll do our best to answer as many questions as we can. If we don't get to your question, just please understand there's a lot of questions we're trying to get to. Plus, we're looking at your question. It might be answered a little bit later in the presentation. And sometimes the question that you ask is a little bit more personable, and we need to kind of know you a little bit more, ask you a few more questions so that we can answer that question. We just can't answer that question as easily without some more information from you. So for those of you that we don't get your question answered, go ahead and still type it in because we'll get record of that. And then when we do have a one-on-one conversation, whether it's on the phone or through Zoom or in the office, we'll make sure that those questions get answered. So don't hesitate and type in that question to us. For those of you who are watching this and you weren't able to get on this on the live version, you're kind of watching the recording version of this, same thing applies. Type in your question, even though we're not live to answer that question, type it in because it does come to us. And we'll make sure that when we reach out and call you and get our time scheduled, we'll get those questions answered as well. So again, I'm here as a financial advisor to talk about the topic of estate planning, specifically long-term care and how that meshes with estate planning. Represent my nonprofit of F3E. And Glenn Stockton of Stockton and Stern is here with me today because he too believes in giving back to our community. With his nonprofit and our nonprofit, it's kind of our way to kind of have some fun, do business together, talking to people, help each other, help the community out without having to always try to sell. And so we really have a good time with this. And so we'll be interactive. My camera's over here. You're going to see I'm going to be looking down at the screen over here at my buddy Glenn. So if my eyes aren't on the camera, that's because I'm looking at Glenn. So I'm going to be trying to navigate the screen while we're doing this together here. So Glenn, I'm going to introduce you, Glenn, with Stockton and Stern. Thank you so much, Glenn, for joining us here today. Take it on. Let's talk about the conversation of estate planning and long-term care.
Okay. So Mark, thank you for having me here. And, your introduction, when you talked about the people who are, facing long-term care costs and the stress that causes, and how are we going to pay for those costs, that is a big piece of the estate planning puzzle. I think it's a piece that many times is missed. I think a lot of attorneys, they don't know this area of the law, right? When we're talking about long-term care planning, Medicaid planning, what are deemed elder law issues, it's a very niche area of practice, a specialized area. So there's a lot of attorneys who don't even have a specialty. And I see it's one of the areas where I see the biggest mistakes in estate planning. And we're going to talk about that today, because when we're going through, we need to make sure we have a plan for that. But there's other things we talk about too. I am an estate planning and elder law attorney here in the Kansas City area. I've been doing this for over 20 years. So let's jump in, Mark, with the types of estate plans, right? These are the big categories of people, of where we see people. We see the people that have no estate plan in place. And many of you that are watching this find yourself in this category where you need to get the planning done, but you haven't done the planning, and you know that we've got to get that remedied, that's just a recipe for disaster. Others of you have a will as kind of the centerpiece of your estate plan, and hopefully you have some other documents that back that up, and others have a trust, and where the trust is the centerpiece of the estate plan. We may still have wills and the other documents to back up. So these are the three broad categories that most people find themselves in. And with a vast majority of the people we work with are either going to be will-based people or trust-based people. I'm a big believer in trust. Trusts are fantastic estate planning vehicles. And we're going to talk a little bit throughout the presentation here as to, the advantages trust can bring. But I am not one of those attorneys that believes everybody needs a trust. There are some of you that will find that you are will-based people, and others, we need that trust. And hopefully we identify that early on. But I do hope that we can agree that having nothing in place that is not a good plan for any of us. Because when we don't have a plan in place, we are unprepared, and we know we're unprepared, right? Right. With the idea, Mark, perfect. With the idea is that we want to be prepared. And we don't have the crystal ball. I don't know exactly what life has in store for myself or for my clients. So we do the planning. Let's make sure we're covering the bases, that we're being comprehensive in the planning. But we want it to be easy. Just make sure that we are prepared for whatever life may throw at us. Basic estate plan, whether you're a will-based person or you are a trust-based person, there's certain documents, and it looks like, Mark, you've kind of put some notes on my slide here. It goes there, that we have powers of attorneys. You've got your financial power of attorney, so your durable power of attorney. You've got a healthcare power of attorney, your HIPAA authorizations, your living wills. These are all very important documents that each of us need, whether you have a will as the centerpiece of your plan or a trust, and whatever that looks like. These are fundamental estate planning documents that each of you need. And you need to make sure that they do serve their intended purpose, right? Far too many powers of attorneys are insufficient. People don't have their living wills. The living will is the pull the plug document, guys. And I would just urge you, make those decisions for yourself in advance. We hope that never comes to play, but if it does, right, this is the pull the plug document. And if we find it in life, you don't want your loved ones making the decision whether or not you live or die, whether feeding tubes have to be removed. It's a huge burden on them. It's a stress. It's an area where we see conflict among kids. I would encourage you, make that decision in advance for yourself so your kids don't have to do that. HIPAA releases. We've heard about this in the news, and I'm going to give you a quick example of the importance. This is often overlooked as how important this is. But fairly early on during this COVID crisis, there was a gentleman, his wife had a massive stroke at the home. He called 911, the ambulance came, and they rushed his wife off to the hospital. He followed in his vehicle, got to the hospital, only to be stopped at the checkpoints that hospitals have put in. Because of COVID, he was not allowed to go into the hospital, was told, hey, return home. They got his phone number, and they said a social worker would call him. And the social worker called him shortly thereafter and said, okay, we need to get copies of your wife's power of attorneys or living will and her HIPAA authorization. And he explained to the social worker that he and his wife had not done any planning yet. They hadn't got around to doing this. His wife didn't have any. And she had to explain to the husband that unfortunately she could not share any information with him because the wife had not authorized the hospital to release information about her health care or her situation. And so she encouraged him he would have to reach out to an attorney to be able to get that remedied. And so we had to go to court to do that. And you can imagine the stress that was on this husband. His wife was taken by ambulance and he doesn't even know her condition, right? Doesn't know whether she's still alive, how serious things are. And so he reached out to our office and we were able to fairly quickly and you get something filed with the court and get him authorized. But there's a huge stress and burden that could have so easily been avoided with those HIP authorizations. So we don't think about those much, but I would encourage you to get it done. Mark, in your role, you're a financial advisor. You deal with these powers of attorneys all the time. I'm sure you've seen situations on the financial powers of attorneys of the importance of those documents and sometimes where those documents can be lacking for people.
Well, I'd say the biggest one that I see is the financial power of attorney. If they have one, it's old. And sometimes banks, insurance companies, or investment companies don't honor them because they're maybe 10 years or older and they want those updated. Well, when you realize that they're not being accepted and all of a sudden the kids and that parent have to scramble around to get an appointment with an attorney to get all this done and get it updated, it takes a lot of time. So besides that being not updated, the second one is we find that powers of attorney are so much more powerful for you to have your child or somebody else help you with financial things. And you want to do that than to put that child's name on an account. We don't want to add our kids to our bank accounts. We don't want to add our kids to our house. We want to use powers of attorney for those kind of things. It's so much more powerful while we still maintain protection. So that's where I usually see that the most.
And I would say, Mark, into that, the powers of attorneys, yes, they can get, outdated, become stale or a question. But the other big feeling I see with powers of attorneys is that they don't give sufficient power to our power of attorney. We don't have our power of attorney doesn't have the ability to do things that they need to do when they're in that crisis situation, like you were talking about early on, where somebody's going into nursing care. This is a powerful long-term care planning document, but those powers have to be specifically granted to your power of attorney, or they will not have the power. So just make sure that you cover your bases. This should be, it's a key fundamental part of your plan. And just like the HIPAA release, it's one that's often overlooked. It's insufficient. Even ones drafted by attorneys that are not elder law attorneys, they don't have those long-term care pieces in. So I would just urge all of you, make sure you've got these documents in place, and especially with that financial power of attorney, what's often referred to as the durable power of attorney, keep that in place, okay? So those are fundamental documents, but we're looking here, what are we planning for? I mean, why are we doing this at planning? And some of the big common areas, we want to avoid probate, prevent kids from fighting, ensure assets go to our loved ones, right? When our assets go, who we want, when we want, the way we want. We want to protect our assets from the government. We don't want the government taking our home, taking our assets. And we're trying to have a plan in place of how we're going to deal with long-term care costs. And finally, we don't want to be a burden to our loved ones. And that's a big motivator for a lot of people to get this done, because we know if we don't do the planning, we're going to be a burden because they're going to have to do it for us. So I always tell people, get it across that goal line and get it done. And Mark, in your experience, are these the things, these are the big ones that motivate people to do the planning, or what we're really planning for?
Well, the obvious one, I think, of course, is avoiding probate. Everybody wants to avoid probate, and that's the most common thing. But as I bring that up with probate, one of the questions right out of the gate, Glenn, that someone has sent me a question here is, how long does it typically take for the probate process? So what would you say is typical on probate?
So probate process, can 9 months to a year is probably average amount of time it's in probate for a simple probate process. If it's more complicated, they can go on for years. So it is a lengthy process. It's also a very costly process where you're having to hire attorneys typically to get through this. You're having hearings at every stage of the game where everything's got to be approved in court. There's just a lot of expenses, publication costs, and those type of things in. So it tends to be very costly. On average, probably for 5% of the cost of the total value of the estate.
Okay. Minimizing long-term care, I find, is a big question people want to bring up all the time, especially an example I used when I started the webinar here today. This is the two things that eat away people's money is long-term care costs and income taxes. That's while we're alive. And we'll talk about income taxes in a little bit, but long-term care is a big one because most people don't realize it's not just having a will that protects. It's not just having a trust. It's actually having a specialized trust by an attorney that specializes in elder law, which there's not a lot of you out there that do this, and you're one of the very few in Kansas City that specializes in this, to put specific language in a trust to help protect from a spend down of your assets for long-term care costs. And then I'm left to try to figure out how do we spend your money and how do we make sure we try not to run out and try to have a little bit left over without running out of money. And so I find that I'm trying to help out, and there's only so much as a financial advisor I can do. And an attorney with planning ahead has a lot more power than a financial advisor does. So that's the second big one. And then the third one I think is the big one is being a burden to our kids. And to me, our kids are going to step in and do things when we need them to while we're alive, but then the kids also are there when we're gone. This is not a thing that you can avoid burden altogether, period. Even with the greatest estate plan, there's going to be a little burden because kids have their own lives to deal with, and now they're trying to deal with financial stuff, health stuff, legal stuff for mom and dad. So we want to just drastically minimize the burden that we have in our kids when it comes to at that moment when we need help. So to me, I think that's the three big ones, but I agree with you. Those are the things that we're planning for. This is one of my favorite slides. I like this. One day, son, this will all be yours. I think we can all kind of relate to that there a little bit.
It's well, it is. And it just keep it simple, make it easy. And there's no reason this has to be complicated, but we just got to plan for all these issues, the cost of care and avoiding probate.
So Glenn, what I want to do is I want to segue now to what are we planning for, but now let's start spending some more time. What do we want to avoid? Like some common mistakes people make when they don't do their estate plan or they do their estate plan. And the four biggies is long-term care, probate, taxes, and having our family unprotected. We're going to go into a little bit more detail. Glenn, another question just popped up here real quick. I think you hit on it a little bit, but can you elaborate just a little bit more? Probate, you said, is 9 months to maybe 2 years, but the average cost of probate, did you say earlier that the average cost of probate was about 5% of one's estate?
5% of one's estate. It can certainly run more, and it depends on the complexity of the probate process. But that's the 5% of the total value when you add up your home, your retirement accounts, your bank accounts, your home, your vehicles, your home furnishings and personal effects, all of that, about 5%. And so it can be quite costly as a cost of that. But I've seen many of them that run far in excess of that. 8 to 10% it would be for those who've done absolutely no planning, right, whatsoever. You're probably looking at 8 to 10%, 5 to 8 for those who have the plan in place, some plan in place. But many plans, and people don't understand this, just because you have a will does not mean you don't have to go through probate. Wills by their very nature have to go through probate. And we're going to talk about that as we go through here. So
that's the next question someone's asking is it possible with proper planning with my financial advisor and my attorney, it says, to completely avoid probate? Is that possible?
Absolutely. Absolutely. And that is one of the most common goals that we have. When we do an estate plan, I'm yet to have the client who comes in and wants to go through probate. We're always looking to avoid it, and we can easily avoid that with doing the planning. So absolutely. And of our four areas here, Mark, I would say, what we're trying to avoid: long-term care, probate, taxes, leaving our family unprotected. The probate's the one that if you've worked with an attorney who's does estate planning, they probably have a plan in place to help you avoid probate. That's an easy one. It's just that most attorneys, because they're not specific to estate planning, or they don't know elder law. That's where these other three kind of big areas of mistakes where people fall in these other three areas.
Well, let's hop into this, Glenn, and let's take the first piece of this, and let's talk about long-term care. Why don't you tell our audience about the importance of proper estate planning with long-term care?
So when we're talking about long-term care, this is, typically at end of life, right? And so we all think we've got plenty of time, that's out there in the future, or that it's not going to happen to us. And the reality is, we're going to see here in a minute, that it happens to a lot more of us than what we think, and we need that. So we need to do the planning, though. Ideally, we do the planning 5 or more years before we need it. Why? Because Medicaid has a 5-year look back period. And a lot of us have heard of this 5-year look back. What is that?
Now, did you say Medicaid or did you say Medicare?
Medicaid, another area of confusion. A lot of people think, I've got Medicare to pay for it. Wrong. Medicare is your hospitalization, doctor visits, right? It pays for that. It kicks in at age 65. It has very, very limited long-term care benefits. Pay for rehab purposes only, following a qualified hospital stay, and only up to a maximum of 100 days. That is not long-term care insurance. Medicaid is your long-term care insurance, and you've been paying it through your payroll deductions your entire working career. But in order to avail yourself of the Medicaid insurance, they require that you either do planning 5 years before you need care, right? You can't, or you spend down your assets, right? Spend all your money till you don't have money, or do planning at least 5 years in advance. You can't wait till you got a foot in the door at the nursing home to do this planning. And so I would urge you, why I say this should be on our radar screen. When I'm working with young families, right, the biggest threat they have is they're going to die prematurely while their kids are still young, before they get their kids grown up. And so our plan is to make sure that we have that dealt with, that if they do die prematurely, that, we can get their kids through to their minority. But most of us see our kids grow up. And once we do that, and we start getting into the age where we're starting to look at retirement on the horizon, also on the horizon is the possibility for long-term care. And so just making sure that's the biggest threat most of us have, painting with a very broad brush. We just have to make sure we have a plan to deal with it, because it's very expensive. If we don't have a plan, it can be devastating.
Yeah, I would say, Glenn, for me, one of the things I find with long-term care is I'm working with my clients who might be in their 50s and 60s, and their parents are approaching the 80s and 90s. And now their parents are needing care. And now they're kind of being thrust into having to deal with this stuff with their parents. So then I'm the person that they call, even though their parent isn't my client, they're my client. They start asking me questions. Okay, what can I do here? Here's mom and dad's assets. Can Medicaid come in? It's like they do a little research, but they get enough information to kind of start asking me questions to start the conversation. But then when I say Medicaid won't step in until, number one, you're broke, or number two, you started the 5-year clock putting assets into a specially designed trust, so that 5-year clock had started and is over before Medicaid will kick in. I know we'll talk about that more in a minute. So I find that's where I'm usually coming up with this, is talking to people's 50s, 60s, 70s, and we're dealing with their parents that are like the 80s and 90s, and that comes up with me. And I wished we would have had this conversation way before that.
Right. That's because if we do the pre-planning, and that's what, with this 5-year clock, this is the ideal situation we're in, right? That we did this planning 5 or more years before we need it. We hope we never need it. But if we do, that we did that planning at least 5 years or more in advance. When you're dealing with those kids of elderly parents, a lot of times they've not done the planning. And so when we're doing what we term in the elder law industry, we deal with a lot of that here in our firm, of what we call crisis planning. It's where they don't have any pre-plans. And that's what we're really trying to avoid. There's a lot we can do in that situation to help people preserve assets, but we typically are not going to be able to save as much money and minimize costs the way we can when we do the pre-planning. So pre-planning is the least expensive planning you're going to do, and it's the one where you can guarantee you're protecting assets. So you've got a screen here, Mark, it moved on. No long-term care plan. People think it won't happen to me, that I have time. And I'll just tell you that, it was like the story I shared of the husband who didn't have hip release. They probably thought they had time. They hadn't gone around to doing their planning. They weren't expecting that stroke that his wife had. And we see these things all the time. Tomorrow is never guaranteed to us, and what tomorrow looks like, we don't know. So our jobs as attorneys, right? What I do is my job's to hope for the best, but I've got to plan for the worst and make sure that we address the long-term care piece to the planning. If you think it's not going to happen to you, let's look at statistics. Statistically, 70% of us age 65 or older today, 70% of us are going to need care at some point in our life, right? So about 2/3 of us are going to need care at some point. Average cost of assisted living, and this is in Kansas City, just for assisted living, is over $50,000 a year on average. Many of the places that my clients want to be in, are far more than that. Average cost of a private room, if you've got to go into skilled nursing, over $100,000 a year. And these costs continue to go up as inflation. In fact, the cost of care outpaces the rate of inflation every year, and it has been doing that for a lot of years. And when you look at the average stay in communities, we're looking at 4.5 years on average when somebody enters into long-term care, whether they might start in independent living, go assisted living. By the time they get done in skilled nursing, 4.5 years on average for the length of time people are in care. So these are real expenses that can absolutely, if you're having to pay $100,000 a year for care, it's not going to take most people long to spend everything they have, and they end up going broke in a nursing home, which, as I said earlier, exactly what we're trying to avoid.
Now, Glenn, let me hit on this subject here because this is some costs, and let me explain how you can read this. We have 3 categories. We got home health care. So in other words, we need care, we need some help, more than what I can take care of myself, or maybe more than what my spouse can take care of me. So we're going to pay somebody to come over to the house and help take care of us. That's home health care. Assisted living means that now I need to move someplace. I can partially take care of myself, but I can't do everything. So I'm hiring people to do part of the work, part of the stuff for me. And then the other one is kind of like full-blown nursing home, where I need constant care. And the more care, the higher the cost. So these numbers here are like in 2020, the average cost is $4,500 a month for home care, whereas in 2030, it's going to jump from $4,500 to $6,100 because of inflation. Assisted living, it goes from $4,300 a month to $5,700 a month in 10 years. And nursing home goes from an average of $8,800 per month to over $11,000 per month in 10 years. The blue graph is the annual numbers, the yellow is the monthly numbers. These numbers are high. This is the most expensive form of living that we can have, is to basically need to pay somebody to come and take care of us in some capacity. And over time, that cost goes up drastically. And cost of care inflation, as Glenn said, is drastically higher than inflation by itself. So I just want to point this out on how these numbers can drastically erode and eat away our dollars, but easy to minimize or easy to avoid with proper planning, and proper planning now, so you can get that 5-year clock going, get the trust established, protect your assets, and then you can move forward to future care down the road with Medicaid.
Yeah, because Mark is, you're aware when you're writing that check, for $5,000 to the assisted living community, you write a $5,000 check. That's your price of admission just to get to move in, right? And then the very next month, you're writing another check for $5,000, and the month again, you're writing another one and another. And it just continues on, except it's not $5,000 anymore, as you're pointing out. That cost keeps going up. So we want to avoid that situation where we run out of money, we go broke in the nursing home. We want to avoid leaving our home unprotected. And if we do nothing, right, it's very easy to qualify for Medicaid. How do you do it? Spend all your money until you don't have any money, and then you can qualify. But
so this is a perfect time. One of the questions that got brought up is on this slide. If you take a second and just give a little bit more clarification, the question is asking, can the government take my house from me? I think it comes to leaving your home unprotected.
Yes. So what they will do is, if we need to go into nursing care, or our spouse has to go into nursing care, the state will put a lien on your home, right? So that they get paid back any of the money that they're paying for the care, so that home will ultimately have to be sold, and then the money paid over to the state. So that's how they take it. Can we avoid that? Absolutely, we can avoid it. Ideally, if we're doing this planning 5 years or more in advance, which is where we want to be, we do this planning in advance, we can deal with that home to protect it. And the way we're going to do this, the best way to do this is we're going to put it in a properly structured trust, right? A trust that is compliant with Medicaid rules to make sure that that home, that we don't have to sell it, that we can live in the rest of our lives, and upon our death, it goes to our kids. We just need to make sure we do that at least 5 years in advance. So, we want to avoid running money, leaving our home unprotected, and being a burden to our kids. Because if we don't do this planning, and you talked about this at the very outset, the story of how when it's the children of the parents who are coming in and trying to figure all this stuff out because you didn't get it done, now your kids have to do it for you. And it's going to be exponentially more difficult for them to do it. And now they probably don't have 5 years, right? When that's coming in, we're already in a crisis. We got a foot in the door, the fire's in the kitchen. There's still a lot that can be done to help protect assets, but it's going to be a lot more difficult and probably not going to protect nearly as much as we could have if we had just done it 5 years earlier.
So to summarize what I heard you say, and tell me if this is correct, somebody's too late in life and they need to start paying for care. You can still help them, but it's not going to be near as great a protection of their assets had they had started earlier in life. So it's best to start now, but it's never too late to at least do something later. Something later is better than nothing, but the best thing to do is start now, because getting that 5-year clock started and over with. So by the time your health changes, it's more than 5 years down the road. Is that right?
Absolutely. There's a lot of what we call crisis planning strategy, division of assets and things like that we can help people. Absolutely. But do yourself a favor and don't put yourself in that crisis. Just get it done in advance. It's going to be the least expensive planning you'll ever do. And it's the one that can guarantee you that all of your assets can be protected.
So let's talk, Glenn, about long-term care again. We're on the subject. How do you pay for long-term care? What are some options to have to pay for these kind of costs?
So, you've got them listed out here, the ways that we can often do that. We can use long-term care insurance if we, purchased long-term care insurance and could get through underwriting and we pay those premiums, throughout our life. We can maybe avail ourselves of long-term care. And that can often be part of the puzzle. But the problem with long-term care insurance is not what it used to be. We can spend our own money, right? We've saved up, and so we can just use our own money to pay for our care. Unfortunately, many times it's the kids kicking in money that pays for care because we've spent all our money. And so now the kids are trying to, they're supplementing our care to make sure that, we get the care we need. And if we're not going to go through the spin down and have our kids pay, then we need to look at doing planning and have a legal plan in place. And again, I hate to keep coming back and beating this horse about the 5-year plan, but you want to do this 5 years in advance. And if we put a legal plan in place, now we have assets that can supplement, because Medicaid's probably not going to pay for everything you want. For example, you want Medicaid pays for a semi-private room, meaning you get a roommate, right, with a curtain down the middle. And so you've got somebody maybe with dementia wandering through the room at 2 a.m. You have to have the client who wants that. Clients are very social people, but they want a private room. Well, Medicaid doesn't pay for it. So how are we going to pay for it? We got to private pay the difference, but there's no money to pay for it because you spent all your money down. So another reason we do the planning in advance, so we have the ability to pay for that private room, to pay for things that Medicaid won't pay for, and also then to make sure that money goes to our children or our loved ones at our death when we no longer need it, rather than going to the state.
When I look at these 4 options, this is what we talk to our clients about too when they start asking about it. And we sell long-term care insurance, but the disadvantage of long-term care insurance is you got to qualify. You have to pass medical examination. And 2 is you're not guaranteed to collect on it. So it's kind of like car insurance. I can have a car, have insurance, and drive my whole life and never have a car accident, but I don't get a refund when I die of all those insurance premiums I've been paying. So long-term care is the same way. So there's a disadvantage that you're risking. I'm going to pay all of the insurance company this money, but I don't get to collect on it later. Of course, number 2 is spending down our money. We don't want to save all of our money to basically have all the money go to the cost of care, and then we pass very little or nothing down to our children. We'd like to pass an inheritance down to our children instead of having it spent on care. Of course, we don't want to ask our kids to pay. Most people I know that have had those problems where they ran out of money, they would rather be willing to move into the nastiest, cheapest place they can go to than to have their kids pay the bills. They just don't want to do that. So the 5-year look back and planning ahead and spending just a little bit of money right now with somebody like yourself, with a lawyer that can draft a proper estate plan with proper trust is so much cheaper than long-term care insurance or spending down your assets. That is by far the best way to go. So on the subject of the 5-year, let's take a minute and just talk a little bit more about that. Well, that's the next slide. Can you add a little bit more to that and talk about the difference between Medicare and Medicaid? You mentioned earlier Medicare is for health insurance. The Medicaid is for long-term care.
Right. And let me just real quick, just the thing you did. One of the things that a lot of people think if they go on Medicaid, they are going to those horrible, nasty nursing homes that we remember from the 70s and 80s. And what I say is that's not the case anymore. There's a lot of very, very nice communities and more like resort living that accept Medicaid. So we want to be able to qualify for Medicaid, but we're subject to this 5-year look back. The 5-year look back is a series of questions on a Medicaid application, and they're looking to, did you give away money that could have been used for your care? Anytime within the last 5 years, did you give money away? Did you transfer it to a trust? Did you sell property and didn't receive full market value? Maybe you tried to, well, I'm going to sell my home to my kids, but I'm selling it to them for $20,000 when it's worth, $150,000. So they're looking for those kind of things. And if we did any of that within the prior 5-year period from the date of that application, then Medicaid says, that money that you transferred away or, put in trust is still available for your care. And they'll create this penalty period, which is designed to say, hey, you got to go back and somehow get that money back and spend it before we're going to pay. So that's why the key is it's only those type of moves within the last 5 years. So if we did this planning, we put it into a trust, 6 years ago or 5 years and 1 day ago, it no longer is subject to the Medicaid spend down. It no longer is caught within that snapshot picture of today and the 5 years prior.
Yeah, I made a note up here on the 5-year where I see this also kind of an issue is this isn't just something, Glenn, that a specialty attorney like yourself has the knowledge to create the estate plan with the proper trust, with the proper language for this. It's not just your responsibility, it's also the financial advisors. And I say that because there are assets that we want to put into the trust, and then there are assets that can't go into a trust. So based on everybody's situation being unique and based on their different assets, whether it's real estate or it's investments, different things can go into the trust and not go in the trust. So the things that don't go in the trust, we have to plan for that and how we deal with that. How do we deal with that so that we can take assets that don't normally qualify to go in a trust? How do we make it qualified to go in the trust? And then the other assets that naturally qualify to go in the trust just needs to get in there, which means we've got to change the title or we got to change the beneficiary. We need to get it into that trust. And I find most of the time people who have a good estate plan, they'll come to me, and as I start talking to them, I'm finding they have a good financial advisor, they have a good attorney, but they haven't worked together on this topic for clients. And that's one of the things I love about working with you guys is your office is always working with our office on making these things happen for folks.
As you've heard me say before, I see estate planning as a team sport, and your financial advisor is a key player on that team, and your attorney and an advisor need to be talking. Mark, one of the issues I see, you guys do a great job. You and your firm understand the long-term care and what assets can move in, but so many advisors don't. I can't tell you how many clients that I've had come in. Well, my financial advisor said, all I need is beneficiary designations. I don't need any of this stuff. Well, beneficiary designations get your assets at death, but it does nothing for you while you're alive. It's not going to avoid long-term care. So, that's likewise, we work with advisors who understand this stuff. You got to make sure you've got an attorney who understands that does elder law, and work with financial advisors who understand this and how the taxes and all that. So anyhow.
Yeah, I appreciate you add to that. And, and this all comes back to how do we deal with this 5-year look back? Obviously we need to, this is the kind of person who's more interested in a trust. So if long-term care and protection of a spend down for long-term care, if that's important to you, then probably a will-based estate plan wouldn't be appropriate for you. You're automatically more of a candidate for a trust-based estate plan because in a trust, you can do these things with long-term care protections. Isn't that the right way to say that?
That would be great. It'd be properly structured trust is going to provide it. There's only 3 ways, right? Because Medicaid, remember I said, they make you spend all your money until you don't have any money. You can only have $2,000 of non-exempt assets to qualify. So you got to spend it down to $2,000 or less. Your options are spend it, do that, give it away, or put it in a trust. Giving it away, You're not doing your kids any favor if you gift it to them. You're creating tax consequences. You've completely lost control of the money. So typically we're going to look at a trust. And with this picture, what we're trying to represent, I think a trust, I don't care what type of trust, how we structure a trust. Think of the trust like the family safe. We're creating the family safe and we're putting assets into the safe to protect them. And that's what a trust does. And they are just fantastic estate planning vehicles. And if we're going to do long-term care, a trust is probably going to be the way we're going to do that, because wills don't come in until we die again, right? They do nothing for us while we're alive. So a trust is going to be a key component to that long-term care planning, if that's, if we're concerned with that.
And what I would like to add to that, Glenn, is a trust is the key. You got to have a trust, but the trust needs to be tailored to you, because everybody is different. Your personal situation is different. Your assets are different. Your family makeup is different. Your goals for how do you want to treat your assets and when they go to your children, that's all different. And so it's having a trust is one element, but having it customized to you is a second element. The third element is having it customized to you in a way that also helps you protect from long-term care costs. And if you are the type of person that's already done estate planning and you have a trust, let's say, already in place, good for you. But if you don't remember having conversations between you and the attorney in the past about long-term care protection being built into your trust, that means it probably isn't in there. And that doesn't mean your trust is bad. It just means that trust is much more basic and you need more advanced language to be added to your trust. And a lot of times Glenn can come right in and work with what you already have and what can we do to enhance it. Isn't that right?
Yeah. So, making sure that, it is compliant with Medicaid rules, because ultimately we want these assets, we put them in the trust. We want to be available for our care during our lifetime. And then we want to make sure that they go to our beneficiaries at our death and not to the state. And so, it's not that you can just, I have a trust that protects me. You've got to use the right trust in the right situation. So, Mark, you probably remember these. I had one of these when I was a kid, the little shape sorter, I guess you'd call it. And you got the little different shapes and you got to put them in the right hole. So the stars got to go in the star hole. And I was that kid who was trying to find every way I could to get the circle to go through the star or the triangle in. And no matter how much I tried, it wasn't going in. And when we're doing long-term care planning, it's kind of the same thing, right? You have to apply the right strategy to the right situation or it won't work. You got to have your trust structured for, your situation, customized to you, dealing with, your assets and your long-term care situation. So apply the right strategy to the right circumstance. And if you get this wrong, if you don't do it right, you think you've got it covered, the government gets to come in, the state comes in and pulls those two yellow handles on the end and pulls it all apart and everything comes falling out and your assets are left unprotected. So again, it's the importance, work with qualified professionals who understand elder law, who understand, the Medicaid rules, because there's Mark said earlier, there's a handful of attorneys in all of the Kansas City metro area that deal with that. You need to make sure you're working with me or one of them to do that, because not every attorney is going to be able to help you.
All right. So the second thing, Glenn, I think we want to hit on here is what to avoid. We just talked about long-term care costs. I think the next thing I want to talk about is probate. And one of the questions I have here that someone's asked me, let me scroll through here just a little bit. Okay, we covered how long of probate and what the cost is. The question is, someone's asking a question, and it's a long question, but it has to do with probate being public record. So if you have assets that go through probate, basically anybody can see it. Your neighbors can see it, ex-co-workers can see it, your family can see it. Everything about your assets that go through probate is public record, and you just go out to the local courthouse records and you can get those records and do it even online to see it. So would you take a few minutes? Let's talk about why do we want to avoid probate?
Yeah, so it is a public record, and we've all seen, Elvis Presley, Michael Jackson, those people who didn't get their estate planning done and had to go through probate, and think, well, they should have had it done. But probate, if we boil down to what is probate? It's really a lawsuit you file against yourself after you're dead, right? It's the process by which we take assets that are titled in the name of somebody who's no longer alive, somebody who's dead, and retitle it to the name of somebody who's alive. That's what probate court does. So if we're going through probate, as you said, it's a public record. It's expensive. It takes a time to get through that. It's very burdensome for our loved ones to take through. Yeah, so it's a process that can easily be avoided, And most of the time, if you have an estate plan that you've done, that was probably one of the goals you have. And, this is, most attorneys, whether they're elder law or not, right? Most attorneys, even non-estate plan attorneys, understand, hey, we need to avoid probate. But here's the problem I run into a lot. People have their planning done, right? They did their will or trust, and it's been, many years ago. Laws change, life changes, and assets change, right? We move things around. And so you've got to make sure that if you haven't had your estate plan looked at within the last 5 years, I would encourage you, take advantage of our offer. One thing we offer is, for anybody who's attending this workshop, I'm happy to do a free review of your estate plan. But what we're going to talk about is, how are things titled? Do they have beneficiary designations? We want to make sure that we avoid that probate process. You got to stay on top of it.
So let me just reiterate that to everybody. I think that's a key. And Glenn and I talked about this ahead of time, but he just now mentioned this. Part of your initial strategy session with Glenn is to get your questions answered after today. A lot of those questions are very specific and kind of customized questions about yourself that you want to understand some legal ways on how to deal with that. But part of it is when you come into that first meeting, you want to bring in your will or your trust, your powers of attorney, whatever legal documents you have with your estate plan, bring that in. And Glenn will literally sit there and open it up and go through it with you and talk about what he's seeing, talk about what's in there, and talk about maybe the things that are missing. And he'll talk about that, but then he's going to start asking you some questions to get to know you, get to know your family, your kids, your grandkids, your daughters-in-laws, your son-in-laws, and then understand your assets. We try to understand you, the assets, and your family, and try to put that together. And what you have is either perfect or it's not perfect. And if it needs to be tweaked, he's going to talk to you about, okay, this is missing. We need to add this in here. And sometimes things can just be added, and sometimes we just need to, pull something out and put something else in its place to kind of replace it. So I want to comment on the probate thing here on time. So I found that people come to me and they say, well, Mark, if I have a will and I have proper beneficiaries on things, don't I avoid probate? Yes and no. But not everything we own has a beneficiary designation attached to it. Some things don't. And so a will and beneficiaries by themselves isn't good enough. And a will, by its nature, says, who do I want my stuff to go to while I'm gone, but doesn't give us any protections while we're alive. There's no long-term care stuff. Maybe we don't want to give all of our assets immediately at the date of death to our kids. Maybe we want to kind of stagger it out and spread things out. A will can't do that. So by nature, a will goes through probate and we'll get to your family, but there's a lot of hurdles along the way. So a properly structured trust will help you while you're alive, help you when you're gone, avoid probate, avoid the cost, massive savings to your family, massive tax savings on other things. We're talking about taxes in a few minutes, massive cost overall savings. So there's a lot that we're going to be talking about here. So
sorry, Mark.
I'll say, do you have anything you want to add to that?
Yeah, I was just going to say, that is what a lot of people, they think, wills avoid probate, and not true. Wills guarantee probate. They just tell the court who's to receive it. It's just making sure that if you're going to have a will, that, you can use those beneficiary designations in conjunction with the will. So making sure that, that is customized to you, right? Your situation of whether the will is appropriate, a trust is appropriate, but that will is going to do nothing for us during our lifetime. So I agree.
So I'm going to take on the next one here for us, Glenn, and talk about the third thing that we want to avoid is taxes. Of course, we're always looking to try to avoid taxes while we're alive. So I want to talk about a law that was put in place at the end of 2019. It's called the Secure Act. Now, before the Secure Act was put in place, when we had retirement accounts like IRAs and 401ks, we were required to start taking withdrawals when we turned 70 and a half, do it every year for the rest of our life, force us to pay taxes on that money. If we don't take that withdrawal and pay those taxes on the amount that we're required to do every year, we get hit with a 50% penalty, 50. So write that down, 50% penalty. This rule is called required minimum distribution. And that applies to all of us who are age 70 and a half and every year for the rest of our life. Now, with the Secure Act, that changed, and it got moved from 70 and a half to now 72. So yay, I don't have to deal with it for an extra year and a half. The flip side of it is, under the old rules, when we died, the portion of our assets that go to our kids that are made up of the IRAs and the 401ks, they have to deal with RMDs, and they have to start taking distributions every year. They can cash it all out at once, or they can spread it over their entire lifetime. But they have those options, and if they spread it over their lifetime, they just pay a little tax every year. The Secure Act says it now all has to be liquidated. and your kids have to pay all the income taxes on that money in the first 10 years. So we have RMD issues, but we also have capital gains issues. So I want to run you through an example here of a capital gains. That's a common mistake I find that people make. So here's an example I have on the screen. Let's say you bought your house in 1963, you paid $65,000 for it, but today it's worth $380,000. So if you sold it, you'd sell it for $380,000. But let's say you're one of like many people and you say, I want to put my children on as the co-owner of my account or a co-owner of my house. You put them on the title to the house because when I die, I want them to just automatically inherit that house. It bypasses probate. Okay, that's true. They'll get it. It'll bypass probate. But the problem is, even though we bypass probate in this case, now the kids lose a feature called a stepped up in basis. So what that means is if we take the kids off and just have you on as the owner of the house and you die, then the kids will inherit your house. They'll get the $380,000 house and they pay no income taxes, no capital gains to inherit your house. They can sell it and collect the $380,000 for themselves for their inheritance. But if you put their name on the title early on and then you die, the kids lose the stepped up in basis. And now at your death, the kids are going to have to pay the tax on that house of the difference between the $65,000 that you paid for it up to the $380,000. That's $315,000 of gain. Using today's capital gains rates at 20%, that's $63,000 of taxes. Easily could have been avoided by doing other things with proper powers of attorney, proper legal documents. These sort of things can get your kids to help you take care of your assets, but avoid a capital gains and losing what's called a stepped up in basis. So Glenn, before I hop over to income taxes, do you have anything you want to add to capital gains here?
Well, I can just tell you that is one of the common mistakes, that I just cringe at where I see people do it. And if you've done that, we can correct it. We reverse that back, get the kid's name off there because, oftentimes it's because they want to avoid probate. So they put their kid's name on with them, right? Which then they're losing at least a portion of the step up that they would get. And then the other thing is they say, to avoid Medicaid, that long-term care thing, I don't want the state to take it. So they just get their name off it completely and put it completely in the kid's name. And you did not do yourself or your kids any favor. You created some tax issues for your kids. And so you're absolutely right. We want to protect that step up in basis when we're talking about, our homes and on any of our assets. Manage capital gains, that's easy. And then you talked about the income tax side of things on our retirement accounts too. And I will tell you, so many people, they don't even think about that. But again, you guys do a lot with that planning and help people minimize the impact of income taxes while we're alive. It's not just about taxes at our death.
Before I add to the taxes on IRAs and 401ks, a question popped up a little bit ago, and I didn't get a chance to ask it, was if I have an estate plan like a will or a trust in place, and then I move later in life, in retirement, I move to another state, does my original estate plan work? I have found, I got a lot of clients in many different states, and some have multiple residents and some have moved, that a lot of times their estate plan is still valid. A lot of states have similar laws. It's probably a good idea to maybe have it reviewed by an attorney in that state, or if you happen to be working with that state, you can review it. It doesn't mean that it's a bad estate plan. It doesn't mean that I plan to move later, so I don't want to do my estate plan now. I need to wait till later. No, you want to do your estate plan now because something may happen to you tomorrow. Got to have the estate plan in place now. But if you move, that estate plan for the most time is just perfectly fine. Wouldn't you agree with that?
Well, certainly with trust, right? Because most of the states are uniform trust code states, and contract law, those things, your trust is probably good. But some of those things like your living wills and your powers of attorneys, states oftentimes have very quirky requirements with their powers of attorney. So those things probably need to be updated or at least looked at. So I'd encourage you, if you've had them done in one state and moved to another, see an attorney, have those reviewed to make sure that they're compliant with where you're at now.
So while I'm on this slide here, as we move into continue talking about income taxes and how to avoid income taxes, again, it's going to come back to 401ks and IRAs. And 401ks and IRAs make up a lot of people's assets. That's a big chunk of at least our savings money is in retirement accounts. Those accounts are the kind of assets that we pass down to our kids and grandkids that's going to be income taxable. And that's what's called RMD. Required minimum distribution is where I'm forced to take withdrawals while I'm alive. I die. I pass it to my children at my death. they have to take an RMD, but under the new rules, that RMD is only in 10 years and they have to pay all that tax in 10 years. So if my parents pass, they got me and my sister, I get 50-50, but the 50% part of my inheritance that comes from IRAs and 401ks, that's going to be income added to my income, my wife's income, and then that inheritance adds to it. It takes our tax bracket to a higher bracket, and then boom, we get taxed on all of this at a much higher tax rate because of the new laws and because this is the way this works with required minimum distribution on inheritance. So what we want to do is we want to work on getting Roth IRAs more into people's portfolios, because we can convert IRAs and 401k money over into Roth IRAs, pay a little tax, do a little bit now, do a little bit next year, do a little bit next year, take a little out of the IRA now, pay tax, move to the Roth IRA. Next year, take a little out, pay a little tax, move to the Roth IRA. Do that systematically every year for many, many years to come. That way, as we age, you and I will have less RMDs on our own IRAs and 401ks. Our kids will receive a bigger portion of the inheritance because Roth IRAs are tax-free. And so as I'm talking, I can see several questions popping up right here on Roth IRAs. So Roth IRAs, they grow tax-free. You can withdraw it tax-free. It goes to your beneficiaries tax-free. And there's no RMD rules. No 72 rules that force us to take withdrawals. I can let that sucker sit there and grow tax-free. I can take it out whenever I want tax-free.
And it goes to your kids tax-free.
It goes to kids tax-free. So a question that gets brought up is, I've been working with my financial advisor, it says here, for a long time, and they're questioning, why would my financial advisor ever mention Roth IRAs to me? I don't really know. I can tell you that, like Glenn, there's a lot of attorneys that do estate planning, but there's attorneys like Glenn that are specialists in estate planning. He's the surgeon of the legal world when it comes to estate planning, dealing with this kind of legal planning for elder law and long-term care spin down. Well, like me, there's a lot of financial advisors that we wear a lot of hats, but there's only so many of us that specialize in tax planning strategies that helps minimize the income taxes while we're alive, and then minimizes the income taxes to our kids when we pass down. And when you see these numbers like compared side by side of not planning versus planning with tax strategies, it's night and day difference. And then we coordinate our planning efforts with Glenn's planning efforts on what he does in the estate plan. Wow, it's amazing what that can do. And it's really not that complicated. And it doesn't really take a lot of time. Just need to have a few conversations with you. You got to have a few conversations with us, but that stuff's easy to accomplish. So that, the third thing of this that we want to hit is, how do we try to avoid, drastically minimize the income taxes? So as we shift into the fourth topic here of what we want to avoid is unprotected families. So Glenn, that's kind of a funny way to say that, unprotected families. Obviously, we want to protect our families, but can you elaborate a little bit more on that?
Yeah, so there's a lot of things here on the family side, So as I said before, of these four areas, probate's one that if you're staying on top of it, you've done your estate plan, you've probably got that covered. But most of the time, people are not thinking about the end game, and so protecting your family from different threats that can arise. So what are we talking about? Well, the blended family, right? One of those areas here, and we're seeing it more and more frequently, where we have blended family, where husband has children from a prior marriage, wife has different kids, maybe they don't have any children in common, or maybe one of them's in common. This cartoon I found kind of humorous as we go in, that kind of makes the point of the blended family. And so we want to make sure that, husband and wife each want to make sure that the children are treated fairly. And so what I can tell you, if you have a blended family, that beneficiary designations are probably not going to make sure that your assets go to where you want. A will's probably not going to work because those things will be changed. You're probably looking as a trust as being the best plan for you, because it's the only way that we can guarantee at the death of the first spouse that things don't get changed so that the assets end up going to the children of the other spouse. And it's not, you may say, well, I trust my spouse wouldn't do that. We find it's often maybe unintentional that these things happen. Maybe it's the kids themselves who are kind of putting paper under, dad's nose and say, hey, dad, I need you to sign this. And they know what they're doing. But oftentimes, your kids, as you get older, they're not thinking about, your deceased spouses who was not their mom or dad, their kids. So it can happen. Trusts are a great way to protect for the blended family.
So let me add to that real quick is, what if you don't have a blended family? What if you've never been divorced and you're still married to your first spouse? But having proper planning, helps protect your kids in the event down the road they start to have a blended family. Right now, maybe they're still married to their first spouse, but what happens if your child goes through a divorce and then they remarry spouse number 2? They have kids from their first marriage. The new spouse has kids from their first marriage. They're having a proper plan in place for your estate plan helps protect your assets when it goes to blended families as well. So whether you're blended or your family below you in the family chain is blended, protection. One of my favorite slides is this, is the kind of the kids fighting over the inheritance. So Glenn, I've found over years when I talk to people about, I need to refer you to an attorney to get your estate plan. One of the things they'll say is, my kids will not fight. In fact, I don't know if I've ever had in my career more than maybe 1 or 2 times that I can really, really think of that people ever said, Mark, my kids are going to fight. No, they say my kids won't fight. And I'm not really worried about kids fighting. What I'm worried about is mom and dad are gone. You guys have passed on. Now your kids have a chance to divide up these assets. Now they have this influx of money and assets. And not just money and assets, but it's personal belongings and heirlooms that are sentimental. So your kids, let's say, may or may not fight over it. But what if your son's wife has an opinion? What if your daughter's husband has an opinion? It's those daughter-in-laws and son-in-laws that kind of pull the strings of our children and give us that conflict that happens. And I can't tell you how many times I've come across situations where families will pass on, kids will fight, and then for the rest of their life, what happens is they no longer are friendly to each other. There's no birthdays, there's no holidays. Everything is sent through a card through the mail because they had that little rift early in life when mom and dad passed.
It's down to making sure your assets go to who you want, when you want, the way you want. And that's what estate planning is about at the end of the day. This is one, and Mark, just real quick on this is spouse remarrying. This is one of those things that people don't plan for. It's why I'm an estate planning attorney today. So I was an undergraduate, right? I knew I was going to go to law school, but I hadn't gone to law school yet. And my grandmother unexpectedly died, and my grandfather remarried very quickly thereafter. And then when he died, all of those assets ended up going to his new spouse. Nothing went to my mom, who was an only child. And I knew that shouldn't have happened. He didn't do any planning. My grandparents had done no planning. And so, making sure that we have protections in place. So it's not that our spouse can't remarry, because statistically, especially us guys, right? If we lose our wife, guys remarry at a much higher rate than women. We become very eligible bachelors. Casserole dishes start showing up. We just need to make sure that we have a plan in place to make sure that if a spouse does remarry, that the assets don't end up going to the new spouse. And it's easy to do, but we got to make sure we incorporate it into our plan. So those are all kind of family issues that can come up and that we're planning for. And there can be lots of others, but it's just idea of making sure that we're thinking through who we want the assets to go to, how we're going to get to them. And we can put a lot of protections in for our kids, right? To make sure it's divorce protected, bankruptcy protected, creditor protected. It doesn't end up, if they go through a divorce, it doesn't go to their spouse. And those are all things that a properly structured estate plan can do. It comes down to being prepared, right? Don't leave yourself unprepared by not doing the planning. So get yourself prepared, put a proper estate plan in place. And you can ensure that when you go to your grave, or if you need long-term care, that we are not going to end up in one of those disasters we talk about. And those are just common things that are overlooked as people do the estate planning process. So keep these 4 things on your radar screen. Mark, that's all I have. And so you've got it here on kind of next steps. I'll let you kind of talk people through where to go from here. And if you have any further questions, I'm free to take some of those up.
Well, Glenn, thank you so much for being on today's webinar and representing my nonprofit to help give back to Kansas City. We're both very passionate about what we do here with folks in the Kansas City area. So thank you so much for that. As a reminder, at the bottom, you have a chance to select a box to request an appointment to have a complimentary strategy session with Glenn. Now, based on Glenn's schedule, it's either going to be him or one of his a couple of attorneys in his office that will work directly with you. But somebody from my office, from our nonprofit foundation, will be with you on that first meeting. We might just sit there to be helping answer some questions, but we might also give you some ideas to help facilitate some of the conversation between you and the attorney on things that are estate planning that's financial. So we'll be there with you on that initial meeting just to help move that along and help get those questions answered for you. So we're a part of that as well for that initial consultation. So select that box and go through and pick your date and time. Again, first come, first serve to kind of get on Glenn's calendar. So do that as quickly as you can. We will call you back and confirm this with you. Make sure that that's still a good date and time. Questions, I just want to say thank you for those who asked questions. There's clearly more questions here on the screen than I was able to get to. I did my best to get to a whole bunch of them. Some was kind of what I predicted. Questions were a little bit more longer, and it's hard to kind of read that as we're going through it. Some of them were specific where I didn't have enough information from you to ask or answer that question or to ask Glenn that question without knowing more from you. So those kind of questions are great questions that we want to answer for you in person. So for those of you who didn't get your question answered, write that down and bring that in with you in the first appointment. You think of some extra questions, don't hesitate, write them down, bring those in as with you as well. In that first meeting, again, bring in any legal documents if you have them. Powers of attorney, wills, trust. If it's relatively new, if it's relatively old, don't matter, bringing them in. That first consultation to have a conversation with Glenn on strategy about this, look at that stuff and see what we can do to make life a little bit better for you. So Glenn, other than that, you have anything you want to say to finish off with?
Yeah, just just say that really, what we're offering here is a little more roll up our sleeves and really dive into and figure out what is the best plan for you as we do this. So I think it would be worthwhile. Hope you find it worthwhile. Mark, thanks for having me on. I've enjoyed this.
Absolutely, buddy. Thank you. And I hope a lot of people got a lot of great value of this. I think you did an outstanding job. I know we tried to keep this quick, but thank you again. And we'll get into much more detail in those individual sessions that people want to have with you and answer a lot more questions and kind of peel that onion back as deep as they want to go. So thank you again, buddy. Hey, be safe, everybody. Thank you for your time.
All right. Thanks, Mark. Take care. Thanks, everybody.